Good morning, ladies and gentlemen, and thank you all for joining us in today's webinar. Coming live to you from ICJ Kenya studio. My name is Silas Kamanza, and I am joined by Jane Muhia, who will be co-moderating today's session. Ladies and gentlemen, institutional autonomy of the judiciary, including management and fiscal autonomy, are very important in a democracy. This is because financial autonomy and administration are key to judicial independence. Judicial finance should be exercised free of interference, negative interference by the other arms of government. In the same manner, the executive and the legislative branches administer the funds appropriated for their internal operations. Funding for the judiciary is not a discretionary act on the part of the legislature nor the executive. This is because adequate resources, facilities, and equipment to the courts are important to ensure that the courts function in accordance with international standards. Jen?
Right. Most judiciaries in Africa are allocated funds from the national budget by the legislature and executive. According to a 2009 report by the United Nations Special Rapporteur on Independence of Judges and Lawyers, the recommended budget allocation is 2 to 6%. However, Kenya's budget allocation to the judiciary still falls below the recommended 2% minimum standard. So the most that the judiciary has gotten is 0.99% in the year of 2013-2014, which was still below the 1% of the total budget. And although the national budget has been rising, the allocation to the judiciary dropped and stagnated at an average of 0.7% since the financial year 2017-2018, when the judiciary was allocated 14.6 billion, amounting to about 0.69%. In 2018-2019, it was allocated 16 billion, which was 0.66%. And in 2019-2020, the judiciary was allocated 18.8 billion, amounting to 0.69%. The judiciary's budget has been declining in the background of an increasing workload, with an average of 500,000 new cases filed each year. Article 173 of the Constitution provides for the establishment of the Judiciary Fund. And in 2016, Parliament finally enacted the Judiciary Fund Act after a very protracted struggle. The fund has not yet been set up due to an ongoing tussle between the judiciary and the central bank on the modalities of setting up the fund.
Ladies and gentlemen, I am sure that many Kenyans have been following or followed the CJ interviews. JSC interviews. The issue of judicial funding featured prominently in these interviews, with the JSC panel putting the candidates up to task to explain their strategies in addressing systematic challenges, and particularly judicial funding. It is upon this background that ICJ Kenya is hosting this discussion today to help us unpack the issue. Together with us, we are joined with a distinguished panel of jurists and legal practitioners across East Africa. With us is Jackie Kagume, the head of program, the Constitutional Law and Economy, CLE, at the Institute of Economic Affairs. We have Mr. Martin Masega, the Secretary General at the African Judges and Jurists Forum. We have Dr. Miandazi, who is a lecturer of law at Embu University, and we'll be joined by Honorable Priscilla Nyokabi, the Commissioner at the National Gender and Equality Commission.
Right, and now to just get into the discussions, we'll start with a question to all the panelists. And I think the main question for most people is, what is adequate financing? Of course, we've cited the recommended 2 to 6%, but we'd like to hear your views on what is the ideal funding threshold in practice, and how should the judiciary establish or calculate the required funding? I'll start with Jackie.
Okay. Thank you very much, and thanks for the kind introduction. So in my view, regarding adequate funding, I would give the term adequate the plain meaning interpretation of the word. And when we talk about adequate, basically the word means sufficient or providing enough resources for the intended purposes. So if we are referring to adequate financing of the judiciary, just like we would define adequate financing for any other institution, it will basically be a reference to providing sufficient resources for the judiciary to be able to effectively and efficiently execute the functions that are assigned to it. So we are all aware that the Chapter 10 of the Constitution, as well as other legislation, provides what should be the primary mandate or the core mandate of the judiciary, and that is primarily the administration of justice, and this is through adjudication of cases within the entire court system structure. And they also provide other services to other arms of government. So for instance, when you talk about swearing in of elected officials and other state officers. So when you talk about adjudication of cases, it's a whole, there are also other connected functions that are related, but so how exactly we would go about determining what would be adequate is to cost what exactly are the functions and try and see based on what they are expected to do in order to deliver proper justice to Kenyans, what it would cost to administer this. I don't know if I should go to the second part of the question when you ask about ideal funding, or I should wait for the other panelists to chip in.
Maybe you can just go ahead and respond to the second part.
All right. So on the second part, regarding the ideal funding threshold, you mentioned 2.6 or around 2% as a recommended minimum. For us at the Institute of Economic Affairs, we are a bit reluctant to argue for a threshold for two reasons. One is that adequate resourcing should be on a needs basis. So this is likely to vary over time. So while there may be need for heavy financial investment at a particular time, so say for instance, right now there may be need for heavy investment in terms of infrastructure and automating processes, this may change over time. And if we peg or if we put a predetermined ratio at the beginning, then it may not provide or guarantee value for money in the long run. So at the IEA, we are a bit hesitant to argue or advocate for a minimum threshold, but what we would argue for would be funding based on a proper and comprehensive needs assessment. So that would be our proposal regarding what we see as adequate financing for the institution.
Much, Jackie. Now I'd like to invite Dr. Victoria. What is your view on the question of ideal funding?
Okay, with regards to ideal funding, if you can hear me.
Yeah. Yes.
So adding on to what Jackie has said, I think she covered most of issues to do with funding. But for me, ideal funding, having been a researcher at the judiciary as well, it would involve salaries, of course, to take up most of that funding. And then we would have to include running costs. Now the day-to-day running of the judiciary also needs funding. We have judges who and other judicial officers who require, for instance, facilitation for various activities and so on. Okay. We also have court of appeal judges who go to other stations and so on, who would require facilitation. So we have those running costs, I've indicated salaries, and we would also have development costs. Okay, so making it much more realistic. We're now in the COVID-19 era, and we have seen the importance of ICT, information and technology, especially with courts being virtual. So you would imagine that costs such as having constant internet, or maybe even having a backup generator if electricity is a problem in a particular area, would be quite key. And these are things that go into development funding or even miscellaneous funds within that judicial budget. And so that needs to be catered for the judiciary to provide access to justice, as Jackie rightly observed. And so with regards to calculation, yes, as Jane has properly indicated, there is that recommended percentage between 2 to 6% by the former special rapporteur on judicial independence. And so you find that, okay, that came from a basis where they had done research in various jurisdictions to find out what is required. And they also considered the importance of access to justice to the people. And so they said, yes, there are other competing finances that our state has to meet. We have health and so on, but that 2% to 6% threshold was said to be the minimum required. And to be adequate. And I agree with Jackie that there needs to be flexibility, but even having that, having a cap that it shouldn't go below a certain amount would be helpful, but then not putting it in legislation as something that is compulsory or standard without any flexibility, because as we saw with COVID-19, finances can catapult, they can increase at a high rate, and so there's need to have that flexibility. Okay.
Thank you, Dr. Victoria. Martin.
Having listened to Dr. Victoria and the previous speaker, I have two options. One is to keep quiet. The other is to repeat what they said. If I will repeat what they said, but then say it differently, in any way that makes any enrichment to the conversation, then maybe I will risk and do it. The central role of the court system is to provide an independent, accessible, responsive forum for the just resolution of disputes in order to preserve the rule of law and to protect all rights and freedoms as guaranteed by the Constitution. Now, these broad responsibilities of the courts are clear. But what is more difficult to do is to determine the level at which the judicial branch is adequately funded to accomplish these duties. From the elaboration of Principle 2 of the Commonwealth Magistrates and Judges Association's principles on the funding and resourcing of the judiciary in the Commonwealth, funding to the judiciary reaches the level of adequacy if it provides facilities and equipment to the courts to enable them to function in accordance with international standards and to enable judges to work efficiently and in a timely manner. This includes physical facilities appropriate for the maintenance of judicial independence, dignity, and efficiency, judicial and administrative personnel, and operating budgets, which, as Dr. Victoria has already alluded to. Further, in 2012, the National Center for State Courts in the US developed some principles that address the adequacy of court funding, as elaborated here. One, that courts should be funded so that cases can be resolved in accordance with recognized time standards by judicial officers and court staff functioning in accordance with adopted workload standards. Two, responsible funding entities should ensure that courts have facilities that are safe, secure, and accessible, and which are designed, built, and maintained according to adopted courthouse facilities guidelines. Three, that the court system should be funded to provide technologies, just like Vicky said, that are needed for the courts to operate efficiently and effectively, and to provide the public services comparable to those provided by other branches of government and private businesses. Four, that courts should be funded at a level that allows their core dispute resolution functions to be resolved by applying the appropriate dispositional alternative. Five, that courts' fees should not be set so high as to deny reasonable access to dispute resolution services provided by the courts and that courts should establish a method to waive or reduce fees when needed to allow access. So broadly, that's how I would put it.
Thank you so much, Martin. You've given us quite a good background on what adequate financing looks like at the regional level. Thank you, Dr. Miandazi, for those very good overview and very good overview on what you think judiciary funding should be. And also thank you, Jacqueline, for giving us a very good background in terms of what IEA thinks, telling us that, yes, there could be a reason that we ought to, for example, give judiciary more than 2% that we are thinking about. And so therefore there needs to be done a needs assessment on that. And the fact that, that is true, especially in the COVID-19 pandemic, this is something that we really need to look into in a very, very keen way. Thank you for that. Moving forward, and would like to open this discussion, going deeper into this particular discussion. I'll start with Jackie. Jackie, looking at 2015, across 2015, members of parliament threatened to have budgetary cuts on the judiciary after the judiciary ruled that the CDF fund was unconstitutional. In 2017, we saw budget cuts on the judiciary, mainly because they had ruled against, they had said that we want a fresh elections, and money was, the budget cuts were actually done so as to raise money for the fresh presidential election. Also in 2018, we saw monies that were intended for medical insurance for judicial officers being reduced, and we also saw the development budget of the judiciary down to maybe 50 million, and so the judiciary was not able to do anything. Jackie, to open up this conversation, could you maybe expound to us what is the trend of judicial funding in Kenya? What does the budget cycle look like from a judiciary perspective? What is there something like overfinancing and issues of absorption? I'm sure that IEA has interacted much with this topic. Over to you, Jackie.
All right, thanks, Silas. So to go into the discussion on judicial funding, basically to understand what the trends in funding the judiciary look like, we looked at two things. The first is basically an assessment of the overall budgetary allocation to the institution of the judiciary, and this is as a share of total government spending. And I think a bit of this was mentioned in the introductory remarks. And then the second thing to help us understand the trends is looking at the budget trends that we see within the institution itself. And here basically we look at how the budget is split between recurrent versus development, and the budget performance at the judiciary, looking at various indicators such as the absorption rate. So based on the numbers that we have, just trying to do a comparison of the allocation to the Kenyan judiciary vis-a-vis the overall national budget. I think you provided some numbers, but the numbers that we have here at the IEA, looking at the last 4 financial years from 2017-18 to 2020-21, so from 2017-18, we had 13.7 billion out of a 2.29 trillion overall budget, and this represents 0.59%. In the subsequent year, the allocation of 14 billion, which is 2018-2019 financial year, represented 0.47% of the 2.55 trillion overall budget. In 2019-2020, we all know the overall budget hit 3 trillion. The judiciary budget still remained at 0.52%. And it was, in actual terms, it was 15.9 billion. And then in 2020-21, they were allocated 17.4 billion out of the 3.165 trillion overall budget, which represents 0.55%. So looking at this comparative perspective of the allocation to the institution, as in comparison to the overall national budget, we can draw two conclusions. The first is that the allocation is obviously consistently below 1% of total spending. Then the second is that while we see in actual terms, in nominal terms, when we see an actual increase in the amount that is allocated to the judiciary, looking at it in real terms, the growth has not been, there is no real growth that we can note because as a share of the total budget, it's actually stagnated around the same percentage points. So that's the first aspect we can look at the trends in judicial funding. If we go to the other way of looking at it, is to look at the judiciary budget, basically looking at the funding within the institution itself. And here we look at how the split is in terms of the recurrent versus the development budget, again, for the last 4 years, beginning from 2017-18 to 2020-21. And we see that the split for the in 2017-18, 18-19, and 19-20 was roughly around 90% for recurrent expenditure, vis-a-vis 10% for development expenditure. Then last year we had a split of 84% for recurrent and 16% for development. So that tells you that the bulk of the budget or the bulk of the expenditure within the judiciary goes towards recurrent costs. And I think we all know what comprises of recurrent costs. These are basically what Vicky had mentioned earlier, including salaries, other running costs like rents, trainings, purchase of motor vehicles, and so on and so forth. And then for development, it basically covers any investments that are done towards infrastructure development or towards automation of processes, just basically the establishment of new structures to help in facilitating the judicial processes. So that's the split. So we see the trend in that respect. The bulk of the spending goes to recurrent expenditure, while development takes up a very small percentage. Then if we look at the absorption trends within the institution, and that's basically an assessment of how the institution has utilized the funds that are allocated to it. We see that from 2017-18, the absorption for the development was 108%. For the recurrent, we had 86.7%. Then in 2018-19, looking at this data is provided in the control of budget reports. So how they calculate or how they indicate the absorption of expenditure, here they look at expenditure of the institution as a fraction of the revised gross estimates. So, and the reason I highlight this is because we, again, at the IEF feel that this may not provide a very clear or the full picture, if I may say so, and I'll explain why. Because, so again, the absorption rate that was provided for 18-19 for development was indicated as 45%, and for recurrent was 100%. Then in 19-20, the development absorption rate, the absorption rate for the development budget was indicated as 79.5%, while that of the recurrent was indicated as 98.8%. So if you look at, for instance, the 2018-19, where it's indicated that the absorption for the development budget was low, it appears that it was 45%, which may appear low, but in reality, the calculation of this is that the control of budget, they calculate the expenditure as a fraction of, again, as I've said, the gross revised estimates. What though is the challenge is that this is not, it's not reflected of the terms, the monies or the funds that they actually received. So there's a difference between the gross revised estimates and the exchequer releases. And here the exchequer releases is basically what the institution received at the end of the day. So if we actually calculate the the expenditure by the judiciary in terms of the development as a fraction of what they received, which was the exchequer releases for the financial year 2018-19, it would be 114%, and for the subsequent financial year, it would be 178%. And I know somebody would ask, how can they absorb over 100% of the budget? And here, what could be a valid explanation would be that looking at the funds, sometimes other than the funds that they receive from the exchequer, it could be, for instance, when it could be that the extra amount was what was received as donor funds. So because this here exactly we're talking about on the development side. So the reason why in 2018-19, for instance, they could have spent 200 million more than what was allocated of the amount was because maybe it could have been a World Bank project where, so the 200 million could be accounted for in funds received from elsewhere that were not coming from the exchequer. So in all fairness, if we are to look at the absorption trends within the judiciary, they have been absorbing, it has been quite commendable in terms, if you actually look at what they spend from what they've actually received. Because for the recurrent receipts, almost 100% throughout. And then again, for the development, if we calculate it fairly, then we also see that it's 100%. So that's the second way in which you can look at the trends in the budget or in the judiciary funding. You also asked about for me to provide more clarity on the exact line or on the process of funding for the institution. So here I would say that the legal framework for the budget process is outlined under the Public Finance Management Act, and specifically Section 35 provides for how the entire budget process, the stages of the entire budget process. So the overall budget. But then just to highlight specific requirements or specific provisions that touch on budgeting for the judiciary, because those are also mentioned under the PFM Act. We have Section 25(4) of the Act. This provides that the National Treasury shall include in the budget policy statement proposed expenditure limits for the national government, including those of Parliament and the judiciary, and indicative transfers to county governments. So that's the first. Then second, we have Section 25(5), which then provides that in preparing the budget policy statements, the National Treasury shall seek and take into account the views of various bodies. And the ones that are given prominence here are the Judicial Service Commission and the Parliamentary Service Commission, as well as the CRA, which is the Commission on Revenue Allocation. So then in terms of process, Section 37(4) again of the PFM Act provides that the Chief Registrar, I think we all know that the Chief Registrar is the accounting officer here, so is the one who is tasked with preparing the budgets for the judiciary. So Section 37(4) of the PFM Act provides that the Chief Registrar of the Judiciary shall no later than the 30th of April in each financial year submit to the National Assembly the budget estimates for the judiciary, including various appropriations. Then the Chief Registrar, while submitting or after submitting the budget estimates to the judiciary, he or she is also required to provide a copy of those estimates to the National Treasury for their review and also so that they can make any comments. So once those are submitted by the 30th of April of each financial year, the CS Treasury is required to review them, and no later than the 15th of May, the CS is then supposed to make any comments that they have on what the CRJ has proposed, and those comments are supposed to be submitted to the National Assembly. So after receiving the comments from the CS Treasury, then they review what the registrar had proposed. They look at the comments that have been made by the Treasury, and then they review and consider this and approve, do their approvals with or without amendments. So Parliament then basically reviews and considers the proposals and passes what they think in their view should be the judiciary's budget for that year. Then if I look at, then the next thing that you asked was what would be alternative sources of funding. So that's this, yeah. So regarding, other than the main allocation that is provided under the annual national budget, which should be the core, obviously the core source of funds here, the other main alternatives that I see, in my view, would be grants by various development partners. And here we have the likes of the World Bank and other multilateral organizations. So basically, funds from other interested development partners. And then how the money is expended, I think I've already covered this because you also asked how the money is expended. I've already sort of covered it when I mentioned the split between, it's a split between some money going towards development and some money going towards recurrent expenses. So I'll give an example of the last year, where we had a split of 84%, 86 or 84% going towards, let me just recall. Yes, 84% going towards recurrent and 16% going towards development. So for the recurrent side, salaries and emoluments took up the lion's share at 65%. Then other operations and use of goods was around 13.8%. Medical and insurance costs 8%. Then we had court operations at 7.8%. Purchase of motor vehicles at 2.4%. Then we have other smaller budget lines for other recurrent costs. Then on the development side, then we had the bulk of it going towards court stations, construction of court stations, as well as the small claims courts, and those are the main budget lines that we see. So I think that's, I don't know if I've responded to the entire question, because I think it had a few sub-questions within the main question, but that would be my initial remarks at this point.
Yes, thank you so much, Jackie, for that. But just before I let you go, there's something which maybe you can talk about quickly, the issue of overfinancing. Is there something like overfinancing, and would this actually compromise judicial independence?
Okay. So I wouldn't, well, overfinancing, how I would say it is, if you provided too much of anything would not be good. If you provided excessive, more than what is actually sufficient, then obviously I think the first thing that would, the first consequence would be wastage. It is unlikely, it is, well, on a positive note, it could be that, well, maybe the judiciary has such proper or good structures, so they're able to actually advance or do more with the money that is allocated. But it could also lead, on the negative side, it could also lead to wastage, which we've seen in most institutions here. So overfinancing, I think a likely consequence could be wastage and of resources. And other than the wastage, I think this would obviously translate to a no value for money for the resources. So, for every shilling that the government spends, the citizen should be able to receive commensurate value in terms of services, in terms of what is provided, what it's able to provide. So again, I think if you overfinance, we could see it could lead to no value for money, where we actually end up spending more, or bloated or inflated. We see things like inflated procurement. So it's in my view, maybe in one which could also exacerbate corruption. So I would say three things to respond to you, Silas. So it's unless they have very good structures to actually use the money properly, a likely consequence of financing would be wastage, no value for money, and likely corruption. Would it compromise independence? Possibly. I would think possibly yes, because again, if for instance we have an increase, or we see an increase in corruption, then there's a direct correlation between that and reduced independence, where maybe some of the judicial officers would compromise in one way or another. So
thank you, Jackie. I think you've mentioned a very important thing, the issue of accountability. The issue of accountability being a very important thing, and the main purpose of, the judiciary to set up accountability mechanisms internally to ensure that absorption is done in a proper and effective manner to ensure that access to justice is actually achieved. I think I'll let my colleague Jane take over the next session. Jane?
Yeah, thank you so much, Jackie and Silas. I think we move on to Victoria, to Dr. Victoria. And I think I would like you to touch on that issue of what is the role of the executive, the legislature, and then the judiciary in also like advancing its needs. And so my colleague Silas highlighted, of course, the trends. We've seen 2015, 2016, the judiciary makes a decision, and in retaliation, we see Parliament threatening to take funds. The issue of revisiting the issue of the presidential election petition and how that might have affected the subsequent budget cuts and the trends we are seeing. So just your comments on the role of the other arms of government in terms of practice, as Jackie has highlighted what's in law, but how does that now play out in practice and the trends we're seeing in Kenya? And also, as you do that, please also the question of how can courts use their inherent powers to balance and prioritize competing needs for public funds. So the courts also have another role. They are the judiciary. So can they use that opportunity and make decisions that maybe speak to balancing out or speak to better sort of advocating for the needs of the judiciary financially?
Okay, thank you, Jean and Silas for that, and also for Jackie for that very insightful introduction, particularly with regards to the numbers. So with regards to, I'll be speaking about separation of powers, and also with regards to courts and whether they can use, as Jean has asked me, whether courts can use their inherent powers to serve authority to balance and prioritize competing needs for public funds. So first of all, with regards to now just setting up the discussion with regards to what Jackie has mentioned about the numbers, we see that we have, and also about can there be overfunding as well, which then sets up my discussion really well. So we look at practicalities of it all. So we're currently seeing that, as we said, in this COVID-19 pandemic, there's a lot of demand by the judiciary for things to do with ICT. We're also seeing that there are access to justice problems for those who do not have access to the internet, particularly self-represented litigants. How can they be able to use the e-filing, case filing system? How can they be able to be assisted to be able to basically litigate their cases during this time when we are having virtual courts? So we see that there are problems still inherent that haven't been sorted out. And even as we talk about overfinancing, there's the reality that, for instance, courts like Mavoko law courts, they're still using containers for some of the services that they provide. And we see in Embu as well, Siakago, there's some sessions that happen under trees. So even as we talk about funding, we can immediately see problems that need to be addressed. And also to set up this discussion, why is adequate funding important? Adequate funding is important, as Martin stated and as Jackie stated, because of the need to maintain judicial independence. We're coming from a history, pre-2010 history of low confidence in the judiciary. Why was there low confidence? Because judicial independence was at risk. Many of the public and even politicians, for instance, we saw after the post-election violence in 2007, 2008, the ODM party saying that we don't trust the courts. Why? Because there was so much low confidence, and there was that concern that courts succumbed to pressures from the executive. And so judicial independence is important, and tied to that is financial autonomy. And we find that, as Jackie has rightly stated, provisions in the, as stated in the Public Finance Management Act. She's mentioned the requirement, there's the Judicial Fund, which is also provided for under Section 173 of the Constitution. Yes, so that is essentially meant to ensure that the judiciary has its own financial autonomy to support judicial independence. But what are we seeing? From the numbers Jackie has given, we are seeing that things are not going easy peasy as we had thought. We are seeing also from what Silas and Jane, how you have set up the discussion, we're seeing that the Judicial Fund in itself, there are still problems with setting it up. There is an act to put it in place, but we've used, as Jane mentioned, there's that tussle between central bank and the judiciary about the modalities of setting up the Judiciary Fund. And so this is 10 years, more than 10 years on, we are still finding the same problems. And as Silas has also set it up and Jane rightly buttressed, we're also seeing pressures. We're seeing that there are many cases that the judiciary is handling against state organs, and there are judgments that have been given. And also with regards to judiciary funding, we are seeing a reduction of judiciary funding as compared to cases that the judiciary is giving that go against the government of the day. So is there, we can see some, and we can assume that there is a bit of pressure that is being put to the judiciary that you should give judgments that favor the government or else, or rather pressure or something like a sort of punishment to the judiciary of sorts. And so we go now to what can be done. And now this sets up the discussion to the question about whether courts can use their inherent powers to usurp authority to balance and prioritize competing needs for the public funds. So now at this stage, I will wear my hat as an administrative law lecturer and look at separation of powers and also the function of courts and the need to limit each state organ's power in terms of providing checks and balances, as well as to look at issues to do with resources, which are quite unique. And so first to set it up, so we talk about, as I've said, we're talking about inherent power of the court, whether the courts can compel funding, and where does this stem? This should stem essentially from the need to maintain judiciary independence, to discharge the court's constitutionally mandated functions. We've talked about essential nature of access to justice, particularly for the very vulnerable, the increase in courts, in court stations, the adequacy of those which are already there, as I've already mentioned. Some courts have services in containers, and some even operate under trees. And so at the center of it all is a need to balance between ensuring that the judiciary's independence and capability, financial capability to operate is maintained, while at the same time to not put a strain on funding authorities, okay, to be protected as well from overreaching judges or what many term as judicial activism. So to prevent, there's need to balance between making sure the judiciary is sorted out in terms of finances, and also to make sure that the judiciary does not go beyond its powers and overreach with regards to now extending its powers to purviews or to sectors that are said to be properly within the executive's mandate or the National Assembly or legislature's mandate. So let's move to how do we balance that? There are those competing claims. Yes, the executive through the Treasury is supposed to ensure that each state organ, each ministry has adequate resources. And yes, we also have heard from Jackie that there is that loophole, there is that gap with regards to provision of funding by the judiciary. So we find that with regards to financial decisions, constitutional law and administrative law scholars call it polycentric decisions that the court should not have a business dealing with. So what do I mean by polycentric decisions? So these are decisions essentially involving allocation of scarce resources amongst competing financial claims. So we can see that right now, taking the example of the COVID-19 pandemic, we have a great need for healthcare. And so financing a lot of financing might need to go to, or will need to go to, certainly need to go to healthcare. But as well, we cannot ignore access to justice, particularly as many people are losing their jobs and losing them they're being dismissed in an unjust way. We're also seeing a lot of breach of contracts because of frustration and so on, due to the effects of the pandemic. So we are seeing that litigation is becoming increasingly a lot. Okay, Silas and Jane mentioned about there being about 900,000 new cases filed each year, but even now we might see even much more than 900,000 cases being filed in court during this COVID-19 pandemic. So as much as administrative law scholars talk about separation of powers, such that the National Assembly in making decisions about and debating decisions about how much to allocate to the judiciary, and the Treasury in giving advice about how much should be given, that there should be checks and balances such that the independence of the judiciary is maintained and its working continues effectively. And here we're also seeing, and as I have also mentioned, there are external factors such as the need to kind of punish, quote unquote, the judiciary, or the need to, for instance, pressure the judiciary to give judgments that are favorable to the government and so on. So how do we balance that? So constitutional administrative law scholars, and I would agree with them, argue that there is need to check about the allocation of funds by, for instance, National Assembly or Treasury, where it's said to be unreasonable or unlawful. So essentially then, rationality and reasonableness then allow, when there is irrationality rather, or unreasonableness, then the court can have an in looking at polycentric, resource-oriented decisions and finding out whether they should be reviewed and so on. So this is through judicial review. So let us turn again to the Constitution and what it says with regards to judicial funding. As I've mentioned, Article 173 requires the Chief Registrar of the Judiciary to use, to come up with an estimate, budget estimate of what the judiciary will need each financial year. And as Jackie has also mentioned with regards to the Public Finance Act, which gives more provisions as to this, on this, Jackie said that the Chief Registrar of the Judiciary is supposed to, on every 30th of April of each financial year, submit the judiciary estimates to the National Assembly, as well as a copy to the Cabinet Secretary in charge of Treasury. So that is the right way to go, and the approval is supposed to come from the national government. And what have we seen? We have seen that task that is required to be done by the National Assembly being pushed to the Treasury, and the Treasury then, from the financial year of 2014-2015, the Treasury has then bulked the judiciary with other organs for the sector category called governance, justice, law, and order sector, so the GJ laws sector, which comprises of many other state organs like the Ministry of Internal Affairs, Police, Attorney General's Office, and so on. So we are seeing that the Constitution provides that should be a function of the National Assembly and not the National Treasury, which then has been gradually reducing the budget for the judiciary. So we then have an in-way to ask ourselves that this clearly is an unlawful act, and the reduction of funding for the judiciary, while there are many there's a much need for access to justice, and that being improved, we find that yes, courts can actually use their inherent powers through cases even, or through judicial review, to then try and balance the competing needs we have identified, because most of the reasons given for not going through that are actually political rather than real, they're propaganda rather than real concerns. So with separation of powers, yes, there needs to be separation of powers, but when state organs such as the National Assembly or the Treasury exceed their powers, then the court can come in through judicial review to check and come up with a solution. And then with regards to, so I've answered those twin questions, and also just basically about financing. So as I said, I believe that fixing a particular percentage of funding for the judiciary would be helpful, so 2% or more, and noting as well that it should not be inflexible. Okay, so having something to work with is better than just giving it a clean slate and saying that we don't want to put any amount. So we can just say it shouldn't be below this, but it could go higher, or it could be adjusted depending on the situation. And so that is the position. And as well as with regards to the issue about external funding, I just wanted to add, we find that, for instance, as Jackie has mentioned, external funding can come or comes from development partners such as World Bank and so on. But the problem with that funding is that it's pegged on what the donors want to be furthered. So various donors have their own objectives and programs. And so their funding to the judiciary is pegged on furthering those programs. So there's that clash between what the judiciary needs urgently in terms of development and what the development partners want to be furthered. So that can be good, but then there is still that funding gap with regards to what donors want or development partners want to fund and what the judiciary needs. As well, the second thing to point out is the whole propaganda that has been ongoing about some development partners funding the judiciary and wanting to further their own agendas through that funding. So this is inaccurate propaganda, but we've seen how that has then been used to try and water down the claims or the needs of the judiciary. So basically, with regards to funding and with regards to separation of powers and the court's power to review, that is all I have for now, unless Jane, you have further questions for me. Jane, I can't hear you.
Sorry, 1 minute.
Okay, I can hear you now.
Okay, thank you so much, Victoria. I was saying you have covered that quite deeply, but I think I just want, as a follow-up to that, the drafters of the Constitution thought in their very wise wisdom, if we say so, that it was important to establish the Judiciary Fund. It's among one of the very few specific funds within the Constitution. So I think the question for most people is what is the rationale for the Judiciary Fund, and what challenge is it likely to tackle once it is actually in operation? So if you could just kindly expound on that a bit more.
Okay, thank you for that question. So you find that, let's start with where we're coming from. So where we're coming from is a judiciary that was so low in its confidence from the public, and also that was constantly being accused of lack of independence. And that lack of independence came from various constitutional amendments throughout the years for the previous constitution. And those various amendments were supposed to make judicial officers to cower, because, for instance, removing the tenure of judges was meant to make sure that, so for instance, if judges don't do what is required by the executive, they're automatically out. And who was the executive? Remember that we had one party state at a certain point in time. And that meant that essentially the National Assembly, or rather the legislature and the executive, were on the same page, essentially. So, and also that at that time would have ministers always also having been politicians or persons who were members of parliament before. So we saw that that separation of powers was kind of watered down by that previous history about where we're coming from. So when you talk about judicial autonomy is meant to ensure, at that time as well, the executive was in charge of funding for the judiciary and determining what the judiciary should do and so on. So you find that giving judicial autonomy, the judiciary financial autonomy under Article 173 of the Constitution is quite groundbreaking and a big reform. Why? Because the judiciary is then responsible for paying the salaries for judicial officers. So judicial officers don't have to cower because they know that their salaries are being paid by the judiciary itself and not the executive, which might, depending on how, based on past history, it was quite problematic. So also when we look at financial autonomy, we're talking about what the judiciary wants to further. If it wants to further ICT, it can further that. If it wants to add more courts, it can add that. And we have all through decentralization, that is the coming into force of now the county governments, we have seen that that diversification of funding is quite essential. And so the judiciary being an insider and it being responsible for its own budget and the chief registrar of the judiciary being the key administrator is quite helpful because an insider knows what is really needed. An outsider, yes, they can try and come up with ideas, but really an insider is the one who knows best. So the fact that the judiciary and the old system through the treasury was quite problematic and quite cumbersome to use. And so the Judiciary Fund was meant to be quite easy to use and be solely managed by managed by the Chief Registrar of the Judiciary. So that shows us from that history and also from what I've said, that shows us the importance of having now the Judiciary Fund. So Jane, I hope I've answered your question.
Yeah. Yeah, thank you so much, Victoria. I note the emphasis on management of the funds, but do we still need something to trigger the allocation so that we ensure that the money that will be allocated or held or placed under the care of the chief registrar is up to a certain standard? And also before Victoria goes, sorry, Victoria, I would like to encourage our participants, kindly do engage with us, kindly share your questions through the chat. And if you'd like to call in, just raise your hand and we'll be able to see you and give you an opportunity to address questions to our panelists. Over to you, Dr. Victoria.
Of course, and so you mentioned something that touches on accountability. So with regards to administration, we find that under Article 173, it's the Chief Registrar of the Judiciary, who has the initial mandate to administer the funds. And so with regards to accountability and what the amounts are pegged, we find that there are various checks and balances. First of all, the fact that an account has to be given. We've just heard from Jackie about the very succinct and well-put brief summary about the judicial budget and what is how it is used and so on. So from that accountability, we can get to see if there's proper usage or if there's wastage. And also with regards to the National Assembly is supposed to debate on the budget estimates that the judiciary presents. And so you'd find that in those debates, parliamentarians can state, in my county, for instance, in Embu, there's a court station that essentially does not have buildings, enough buildings, that some sessions actually happen under trees. Or you can have parliamentarians, maybe in Machakos County, stating, in Mavoko law courts, there are some services that happen in containers, and it's not so conducive especially because of the heat. So that debate process about the estimated budget can actually lead to additions within the mandate or with the estimated budget or various amendments that can then capture the essence of what other people on the ground and not just internally about what the judiciary thinks should happen. So that was the intention of having Article 173 the way it is. And as I said, again, we can always have an audit about how money is utilized, and then that gives us accountability. As Jackie has mentioned, their organization is doing such a great job to ensure that they do a proper assessment of how money is properly utilized. And I'm sure even if there's something questionable, they can raise it. So that's the importance of stakeholders and importance of civil society as well. Okay, back to you, Jane.
Yeah, I'll take over from Jen. Thank you so much, Dr. Nyandazi, for that very deep insight. And thank you so much for really expounding to us what this concept of separation of power really is and why the Judiciary Fund is actually intended to achieve. And just maybe before I go to the next speaker, that is Martin, as we let Honorable Priscilla Nyokabi to prepare. Maybe a quick question to Jackie later on as she responds to other questions is, what sort of accountability measures exist for the judiciary in terms of absorption of these funds? What accountability measures are there? And then to Dr. Victoria Miandazi, I know you just launched your book the other day on equality in Kenya's constitution. What sort of, and I'm sure maybe Honorable Priscilla Nyokabi will expound on this much more, but maybe you could start thinking about what this judiciary fund could bring to the issue of equality in the country. I'll move to the next speaker, Martin Masega. Martin Masega is the Secretary General of the African Jurists and Judges Forum, and therefore Martin has really interacted at the Chief Justice Forum level, which is a regional forum for Chief Justices, judicial officers to discuss issues of judicial independence. And I'm sure that Martin really can give us a good overview on this. Martin, when we look at the Judiciary Strategic Plan 2019 to 2023, we see that the judiciary has actually asked for a whopping 72 billion to be able to implement this strategic plan. We just want to, you maybe to expound to us more what you think is the comparative practice on the Judiciary Fund across the region. So what exactly are we looking at across the region? How does Kenya compare with other jurisdictions in the Africa continent or maybe even outside? And how will the next Chief Justice ensure sufficient absorption of these funds in the judiciary? Martin, are you there?
Hello. Yeah,
Great.
so hello. So the judiciary fund that you're talking about in Kenya is really at the regional level, I would say it's a Kenyan innovation. You don't really have that. It's not my understanding of the fund is that a separate fund from the other funds generally in the treasury. So most of the judiciaries in the region do not have such a thing actually. So Kenya in that case is a pace setter. So how do we improve absorption? Absorption is a big problem, not just for the judiciary. I think it's a problem generally across the government departments in Africa, and it's not just a Kenyan problem. What I have seen done in some countries, I think there have been studies, there have been conversations that have been undertaken on how to improve absorption. Now, I think in Uganda, the study and the conversation is government-wide, so it's not just about the judiciary. So I think that is the first step, is that the judiciary probably itself could conduct a study to understand, to examine what the bottlenecks for effective absorption are. So once it understands those obstacles, then it can begin to address them. So other than having that study, there are other things that can be done, because this has to be a multi-pronged approach. So the other is to simply have improved planning. You know, without a comprehensive strategic plan, and Kenya does have one, without a comprehensive strategic plan and annual planning, I think it becomes difficult to resolve the question of absorption capacity. The third thing is to match the personnel capacity of the institution, its infrastructure, and the funding levels, because that has to be done. One of the major reasons that leads to the failure in absorption is that is the implementation capacity being low, being weak, because you had more funds than you had the personnel and skilled personnel to implement your projects. That you had, you did not have the requisite infrastructure that you needed in order to plan and to implement your plans. The fourth would be to have realistic budgets. I know that Africa is operating from a very weak base in terms of our capacities to deliver justice generally. So when we are looking at development, there is also the temptation of being ambitious. We want everything good that we hear is happening out there, everything good that will enhance the ability of the institution, of the judiciary to deliver on its constitutional mandate. But we also must bear in mind that effective implementation can only happen within certain timeframes. So we must therefore have more realistic rather than bloated budgets. If things have to happen within 5 years, yes, then we have to have a 5-year program rather than try to compress a development program of 10 years into 5 or 5 into 1. So realistic planning, the budgeting is also key. So those are four strategies, I think: doing a study, improved planning, matching the personnel and infrastructure capacity of the institution together with the funding levels, and realistic budgeting. I think those would help in improving the absorption capacity. I would like to say something about overfinancing, which was being addressed by one of the earlier speakers. Something happened in Uganda recently. The budget of Uganda of the judiciary is 200 billion. It has been 200 billion for a while. Now, just before the elections began, then there were meetings between the judiciary and no, not just before the elections, before the presidential election petition. Yes, the presidential election petition was commenced. It had been filed then. Then there were meetings between the Chief Justice and the President, in which the Chief Justice was lobbying for increased funding for the judiciary. And he was lobbying the President directly, And so from 200 billion, the President then said, okay, now no problem. We're going to, what do you want? No, we're going to make it 800 billion. So that means that the budget increases, fourfold. And what's the explanation? No explanation except that there's a presidential election petition that has been filed. Okay, so talking about the effect of overfinancing on judicial independence, I think you can look at that scenario. We don't know what exactly happened, but we know that it could have implications for judicial independence. Thank you.
Back to you, Martin, giving us that sort of regional outlook. and you've given us a very good example of financing in Uganda. And I know that in Uganda, perhaps in 2018, the Supreme Court of Uganda actually, in a case, had mentioned that budgetary cuts and the lack of enough and adequate financing has actually will actually impact on how the judiciary will undertake its mandate, its constitutional mandate. Could you maybe expound more on what do you think is a trend across the region in terms of how are judiciaries across the region, how have they responded to this problem of judiciary funding? Is the judiciary more out? Is it speaking out more? What sort of help do they need from different partners, civil society actors like us, and you know, maybe that can really trigger the conversation that the next speaker will address. Over to you, Martin.
Yeah, hello. So the question, I think we have spent quite a lot of time in civil society and the judiciaries just discussing, debating the question of judicial independence to get it accepted at all and get it established. Now, it appears that it's being established, and we need to move on and to begin discussing the components of judicial independence. And so one of those components of judicial independence, looking at judicial independence broadly, you talk about decisional independence and institutional independence. Now, one of the elements of institutional independence is fiscal autonomy. And fiscal autonomy is not one of those areas that has been sufficiently, I think, discussed yet. It has not established itself. The judiciaries are raising it in different countries. There are still countries, I don't know whether Malawi is still doing this, but Malawi, I know some time ago, even the budget was being done, presented on behalf of the judiciary by the Ministry of Justice. And there are a number of countries like this, where the budget is the budget of the judiciary is subsumed into the budget of the Ministry of Justice, or whatever line ministry it is. So many countries have not come to the point at which you are in terms of developing the concept. And by the way, this is not just just an African problem. It's a problem even in the countries that, those hallowed countries that we admire, which are the bastions of freedom and independence. I can just go through a few of them to give you an understanding of how complex the question of, or underdeveloped even, the question of fiscal autonomy is. Now, in Belgium, Bulgaria, Croatia, the Czech Republic, Estonia, Finland, and Poland, the budgets are drawn up by the ministers of justice. In Czech Republic, it is drawn up in cooperation with the courts. In Denmark, Germany, and Ireland, the ministers of finance draw up the budget. In Belgium, Bulgaria, Croatia, Czech Republic, Estonia, Lithuania, Poland, and Romania, the draft budget is submitted to the Council of Ministers. In addition, in Bulgaria and Lithuania, the budget is also submitted to the National Councils of the Judiciary, and in Belgium, Ireland, and Estonia to the Minister of Finance. In Sweden, which I think has funded ICJ for quite some time, in the past, the Ministry of Justice reviews and analyzes the budget and of the judiciary, and then negotiates. It's the Ministry of Justice which negotiates with the Ministry of Finance. So it's a very undeveloped area, and so ICJ Kenya does well, to spotlight on this issue and develop it further for debate at the national level and even future, regionally. We need to do more to advocate for whatever equivalents there are of the Judiciary Fund. I know in Uganda there's a movement that has been made where a bill, the administration of judiciary bill was passed last year, with one of its objectives being securing the financial autonomy of the judiciary. However, and it has been lauded quite a lot, even by civil society. But there are elements of that bill that I think would undermine, the fiscal autonomy of the judiciary. When you establish the office of the Secretary to the Judiciary, and then he is appointed or she is appointed by the president, directly by the president, and is supposed to be in charge, of this budget formulation, then what have you done to the judiciary? When you to the autonomy of the institution, when you then establish a judiciary council, on which you have so very many well-placed government appointees, so the Solicitor General, the Attorney General, the DPP, and many appointees from the president, and they are on the Judiciary Council, which is supposed to be advising the Chief Justice on the administration of justice, sitting, at a minimum of 3 months a year. What have you then done to the fiscal autonomy of the institution? So yes, the objective of the bill, it was stated, of the act, was stated to be, the liberation of the judiciary and, allowing it to be autonomous, in financial matters. But the arrangements, which would have to allow that happen, I think do not allow it to actually happen. Although the move was that the objective was to actually equip the judiciary with fiscal independence.
Thank you so much, Martin, for that really great overview. To bring back this conversation back to Kenya, I'd like to call in Honorable Priscilla Nyokabi. She's a commissioner at the National Gender and Equality Commission. She's also a council member at ICJ Kenya. But before I just let her give us her presentation, just to remind our participants, after Priscilla, we are going to have a Q&A where we are welcoming your questions, your comments, your inputs to this conversation. So please raise your hand so that we can pick up on who to contribute. Honorable Priscilla Nyokabi, are you there?
Yes, I am.
Great. We've had a very good and insightful discussion with all the panelists. Jackie, Dr. Miandazi, and Martin Masega have given us a very good insight in terms of what Judiciary Fund looks like, both with the Constitution at a regional level, and bringing back this conversation back to Kenya. We would like to exactly look at the impact of the lack of enough adequate financing on the common mwananchi down at the ground. So maybe just to open up this conversation, what is your view on the impact of the Judiciary Fund on administration of justice, especially for the poor, the vulnerable, for the marginalized people, including women and children? Over to you, Honorable Nyokabi.
Thank you so much. Allow me to speak here also as a former parliamentarian, as somebody who has served in the Justice and Legal Affairs Committee, and somebody who has served in the Budget Committee, and also somebody who has served in the House Business Committee. And so I will answer the question. So I just prepared to do it in two ways. One was to speak to that experience, and two was then to answer the question on access to justice for the marginalized people. But then in terms of the budgetary process, Article 173, I'm sure that has already been put on the table on the Judiciary Fund. But more important for us is Article 221.3, where the Parliament is required. In fact, the Constitution of Kenya 2010 had, in a way, attempted to assist the judiciary in its budgetary processes. And I listened to Martin about what happens with the other African countries. Here in Kenya, the National Assembly is required to consider the estimates submitted under Clause 1, which is the estimate submitted directly by the judiciary. 3 organs in Clause 221 are allowed to submit their budgets. 1, the executive through the Cabinet Secretary for Finance. 2, the judiciary, and 3, Parliament. And so with that, the Parliamentary Service Commission and the Chief Registrar of the Judiciary under Article 127 and Article 173. So actually, part of what I have seen myself for the period that I served in Parliament is that we haven't fully utilized the power that the Constitution of Kenya 2010 has given the judiciary as far as funding and as far as budgetary processes are concerned. And so one of the biggest questions that we now have with the judiciary funding is the interdependence of organs. So that here in Kenya, as opposed to benchmarking judiciary with other judiciaries in Africa, we should be benchmarking judiciary with Parliament, which is another independent organ, and which Parliament here does not suffer lack of funding as much as the judiciary does. And yet in terms of the constitutional architecture, both Parliament and judiciary are supposed to have the same amount of power as far as budgeting is concerned. And so the judiciary now, and this question did come up in the Building Bridges initiative, the question around a fixed percentage for the judiciary, which is what for me I would want to speak about, and which is what I would want to urge organizations like ICJ to pursue. Because budgets are relationship-based, and budgets are affected by many factors, including scarcity of resources. Where I have now reached myself, having served in Parliament, I would urge the judiciary to, for instance, pursue 1% reservation of the national budget as we have it. When the national budget was 3 trillion, that would be 30 billion Kenya shillings. When the budget has now moved to 3.6 trillion, that should be 30.6 billion. And that would, in a sense, allow the judiciary to be moving in line with the developments in the country. When the budget grows, the budget for the judiciary should equally grow. In Parliament, you do know that the CDF is, for example, protected at 2.5% of the national revenue. The budget of the Parliamentary Service Commission is around about 35 billion Kenya shillings. The budget of the judiciary this year is not even 20 billion, as far as I know. And so having a reserved percentage, the executive and the Ministry of Finance, Treasury, does not love a reservation. They talk about the inflexibility of budget, but then given the role and the organ of the judiciary, we should talk about inflexibility of budgets with other things, for example, CDF, but not inflexibility of budget for as far as an organ as important as the judiciary is concerned. And the reason for me, I favor a fixed percentage is to avoid this moving target. 1 year, the money is given, another year, the money is deducted, and that sort of thing. And if you look at the way the Judiciary Fund is worded in Article 173, it actually assumes that the money that is to the judiciary is then paid to that Judiciary Fund. The money that is available to the judiciary should then be set at a percentage, so that if it is 30 billion, then that 30 billion is deposited in the Judiciary Fund, and that 30 billion is not available for either reducing or increasing as politics goes and as far as other country priorities go. On the question of audit, and that has come up quite a lot here, judiciary must then accept to be amenable to parliamentary scrutiny as far as resources are concerned. And I say that because I remember in JLAC, we used to have a bit of a discussion around whether judiciary is amenable to parliamentary scrutiny as far as resources go. And it is clear that independence of the judiciary does not insulate the judiciary from parliamentary scrutiny on budgets and on audits. And especially because it is parliament that can help the judiciary to get the resources that it needs from the executive. And so then judiciary should agree fully, and this should be a running principle within the judiciary, that it is completely amenable to parliamentary scrutiny. And if the judiciary is amenable to parliamentary scrutiny, it then means that they have to be Caesar's wife as far as money is concerned. Because the cases on corruption are going to come to court, it must then mean that we do not have corruption from the judiciary, and we do not have corruption on the resources that the judiciary had. And speaking as a vice chair JLAC, I would say that we had questions on how the judiciary spends its money. We actually pride ourselves with having insisted on the judiciary to create a building department, complete with resources and financial and human resources that go with that building department. Because if the judiciary is building, then it meant that it needed skills and capacity around that area, and independent skills and capacity in that area outside of what is available in the executive. When we come to the audits, and I found Victoria speaking about international donors. It's true that donors can give the judiciary money, for example, what World Bank had done. But we found that World Bank would give money for construction of courts. Our judiciary would, for example, use 400 million of government of Kenya funds for one high court station. And they would use 280 million for a World Bank station. And we couldn't understand, shouldn't you even use the GOK money more prudently? So there was a lot of prudence in how money is spent with World Bank grants and much less prudence in GOK funds. So that question of auditing is very important. And by the time, the year that the judiciary lost 500 million, we actually found a court, a high court station, I think Turkana, that had been budgeted for as high as 700 million, another station at 900 million. The Court of Appeal debacle in Mombasa was, I think, 1.2 billion. And you cannot have that from the judiciary. There must be prudence. And I say this not because there is no, the audit should also be in parliament and executive, but because the nail will hammer deeper in the judiciary when there is misuse of funds, then the judiciary should be even more careful in terms of how it spends that money. In other conversations, the percentage has been as high as 1.5, but just to be safe and to be sure that then you can get the money, then I personally would vote for 1%. And that 1% would also then mean when the courts are building, it's not just the court building, but also residences for judges. We must go to judicial independence in all its facets, including how to enable individual judges and magistrates to perform their role. On the access to justice, on the vulnerable and marginalized, including women, the biggest tool that the judiciary has is the legal aid. And that then means that if the judiciary has more resources, then we can put more resources to legal aid for vulnerable groups and marginalized groups. And for example, ensure that where cases are for children under the age of 18, every child can be afforded a counsel at the expense of the judiciary. When it comes to cases around defilement and cases around gender-based violence for children, all of those cases, and especially now with the conversation on the Romeo and Juliet type of love and underage having sex, all of those questions, the best way is then to have counsel, right to counsel for all the cases involving children. And the best place to home or to domicile such a fund is actually the judiciary through the legal aid structure. Then divisions like succession and family law, and divisions like criminal where GBV cases are handled would then receive the resources available so that those kind of cases can also be done within a year. Those kind of cases can then be done within 2 years. Mobile courts, prison courts, all of those require resources. And so increased resources to the judiciary would mean that there is increased resources for access to justice, digitization, all of those mechanisms really should be available. And digitization has affected us because when counties came, the 47 counties, they were quickly able to have Hansard, the 47 county assemblies. So I think the judiciary can equally have those Hansard mechanisms applicable to them in all the 47 counties. Remember, we are waiting for a high court station in all of the 47 counties. Again, the questions of the far-flung areas and how to ensure that you reach the far-flung areas as well. Supporting the court on the small claims. Remember, the small claims courts also are going to need to be resourced, and not just the small claims. We might actually, as ICJ, need to pursue the Court of Petty Sessions, the Petty Sessions Court. The opposite of small claims is actually the Court of Petty Sessions, so that then the minor offenses can then be done. With organizations like National Council for Administration of Justice, together with the JTI, a conversation on modernizing the penal code. Remember, we have a penal code that is very, very old, with some of the offenses against the poor, like loitering. In a country with unemployment, I think basically many of us are loiterers. Some of those should not be offenses anymore in our court system. They really should be done. Again, then resources in the judiciary mean that your JTI is properly resourced. Another issue that has come up for JTI is actually the question around judges who are unwell. And we had a benchmarking with the American judges. I think there is a place around welfare for judges. So when resources increase, again, those matters can be addressed. Thank you very much. Let me end it there. It's just that I had quite a bit to say, having served in Parliament and having served in JLAC and in Budget Committee, and having seen the tussle for resources, and just, you know, as a politician saying there is no other way. You have to go where the resources are, using the law and using the Constitution. Thank you.
Okay. Thank you so much, Priscilla, and thank you for wearing your many hats and sharing your sentiments from the different perspectives. And I think I'd like to just open it up to the other panelists, especially on that issue of accountability of funds. Of course, with higher allocation of funds, and even as the judiciary seeks to be allocated more funds, then it also comes with the responsibility to be more accountable. So I would like to just hear what the other panelists think are the gaps in terms of accountability for the Kenyan judiciary. I'll start with Jackie.
Okay, thanks, Jane, and all the other panelists for the useful insights to this conversation. So regarding accountability, the main requirements or the expectations for adherence to accountability for the judiciary are not different from those or from the minimum requirements of any other institution that is funded from public monies. So Article 229(5) of the Constitution provides or requires the Auditor General, so that's the mandate of the Auditor General, requires the Auditor General to audit and report on the accounts of every entity that is funded from public funds. So no exceptions are made. So even the judiciary is one of the institutions that receives public funds and is therefore required to go through this process. So the essence of the audit report is to confirm whether public funds that the entity has received have been spent both lawfully and effectively. And so I think they are therefore required, the judiciary, just like all other institutions that receive public monies, they are therefore required to adhere to all financial regulations. They are required to adhere to value for money, because when we talk about lawfully and effectively, the aspect of effectiveness points to value for money. And I've just quickly looked at the audit reports that have been done over the last few financial years. I think most of you may be aware that the Auditor General has been a bit behind in terms of providing audit reports for the national government. So there are a few years back, but the reports that I have been able to find from 2014-15, 2015-16, and 2016-17, I've glossed through, and the reports that the report that was issued specifically for the judiciary, because, you know, the Auditor General can make one of four conclusions regarding an audit to any institution. So they can either issue one, an unqualified or clean opinion, which basically implies that the institution has, rather the financial statements of the institution reflect a true and fair view of the spending within the entity. Two, they could issue qualified. So the first is the unqualified. Two, they could issue a qualified opinion, which is the second in terms of a hierarchy of how now moving towards the bad reports that can be issued. So the qualified opinion basically provides that except for some of the issues that have been raised in the report, he could have given a clean opinion, but there are a few issues. There are some major issues that do not go to the core. They're material, but they're not pervasive in the financial statement. So they do not go to the core. So the Auditor General can issue a qualified statement. Then the third could be an adverse opinion, which is not really bad. And this is where the audit finds that there are material misstatements within the financial statements, and that those financial statements provided should not be relied upon to provide an accurate view of the spending within the entity. Then lastly, they could issue a disclaimer of opinion. And here, basically what they mean is if the auditor issues an entity with a disclaimer of opinion, he's basically, or she's basically stating that he or she was not provided with adequate evidence to even form an opinion. So this is where the entity has actually failed to even provide proper financial statements. And so the auditor is actually saying that they cannot even form an opinion. That's in essence what the disclaimer of opinion means. So when we look at the judiciary, because I've tried to look at what the reports they were issued. So they've received two qualified statements from 2014-15 to 15-16, and then in 2016-17 they actually received an adverse opinion. And here is where I've said the adverse opinion means that there were material misstatements that are also pervasive in those financial statements, and they should therefore not be relied upon. So basically, much as we are advocating for an increase in the allocation of resources to the judiciary, and we are also advocating for adequate provision of adequate resources, then by all means we must also call for corresponding responsibility to account, to do a proper accounting of the funds that have been issued. And the audit reports are done for all other entities. It's not to say that it's only the judiciary or the judiciary has performed the worst. All states, ministries, departments, agencies, all entities, as I've said, that receive funds, public funds, are subject to audit and subject to that requirement under the Office of the Auditor General. So they're required to submit their financial statements and report on how they've done their spending. So we should also advocate and ask the judiciary to adhere, because if you look at the main queries that are raised in terms, and here we're looking at how they should enhance the accountability in the funds they receive. If you look at the main queries that have been raised, and I'll highlight a few from the 2016-17 report, the main issues that were raised are accuracy and completeness of financial statements. There's a question of non-maintenance of cash books, management of interests, pending bills, long and outstanding bank reconciliations. So the auditor raises various queries, and from the information that has been provided, it means that they are not able to, there are material misstatements in those financial statements. So I would say that the main challenges in accountability for this institution, it's for them to, is the requirement for them to adhere to all financial regulations. So the audit reports illustrate to us that they haven't been, well, at least according to the reports that are available, they haven't been, there have been some challenges in terms of the financial records. There have been challenges in terms of pending bills that they need to address themselves to. And so one of the responsibilities that they have is to find ways of making sure that these are sorted out in future, so that even as they call for an increase or allocation for adequate resources, then we are not adding resources, and on the other hand, there is no accounting for it is questionable. I would say that in briefly to start with, unless you'd like me to add.
Thank you so much, Jackie. Pretty good feedback there for the judiciary in terms of what they need to pull their socks up on. And I think now I pass it on to Dr. Victoria on the same issue of accountability. Do you have any further comments besides what Priscilla and Jackie have commented on?
Yes, so Jackie and Honorable Priscilla Nyokabi have really captured well the issues to do with audits and as well as parliamentary scrutiny. And I think I also touched on it as I gave my remarks earlier. And just to add about what Silas had asked about scrutiny as well as ensuring that various vulnerable groups are included, I totally associate myself with the sentiments given by Honorable Priscilla Nyokabi about including vulnerable groups. And just to add, I'd like to add about what else should be covered and what isn't as adequately covered. So for instance, one of the key issues that I really focus on, as well as in my book on equality in Kenya's 2010 Constitution, as Silas correctly observed, is the issue about vulnerability and as well as accessibility to justice for instance, persons with disabilities. So you find that most of the court stations are not accessibility friendly, and it's quite indignifying, for instance, to see persons who are physically disabled and on wheelchairs being carried up the steps so that they can be able to attend, when their cases come up, they can be able to attend court. So that is very indignifying. And with regards to the court stations that are being built, this is the importance of parliamentary scrutiny as well as stakeholder engagements, because then there can be the additions of various things that need to be taken into account. You find some courts are accessibility friendly, but the majority of them are not. As well as I wanted to add about the fact that with the budget cuts, there is also the issue of mobile courts. It hasn't been able to run as properly as it should be. So that is one thing to flag with regards to access to justice. And also there was that suggestion that was made in a previous discussion where Dr. Linda Musuma, the former dean for Kenyatta University School of Law, she identified that with this, with the current situation where we are having virtual courts and it not being quite accessible, for instance, for persons who are poor or other vulnerable groups, you find that there is need to set up stations or even cyber cafes where persons are, or even stations within law courts where persons can be able to get assistance. For instance, self-representing litigants can get assistance about how to upload their pleadings via the e-filing platform and so on. So there's much need for improvement, and especially when we talk about vulnerable groups, it's really not as it should be. And when we talk about audits as well, not just audits, but as well as scrutiny, those are things that should be flagged, and stakeholder engagement is also really important. I think that is all I can add to that.
Yeah, thank you. Thank you so much, Victoria. I think that there is a role for every one of us as stakeholders to address those issues. And then Martin, in case you have any comments on the discussion before we have a few more comments from the participants.
Yeah, I think Priscilla put it very passionately about accountability. And it's very important, actually, that the judges themselves are educated about it, because I think there is a misconception among some of our judicial officers on the scope of judicial independence. And I say this because I had an experience once with a judge in one of the countries in Southern Africa. We were discussing fiscal autonomy, and she was the one responsible for for the preparation of the judiciary budget. And she told me that, you see, I want to be able to prepare my budget and then take it to the ministry or to the parliament, and they just accept it as it is. It should not be questioned. So you can see that there is a huge conception of what judicial independence means. Because clearly, as Priscilla was saying, the judiciary needs to be amenable to accountability procedures, and including audits and scrutiny by parliament and other government institutions. Or it will be this funding can only be a harbinger of waste and corruption within the judiciary.
Great. Thank you so much, Martin, for that quick response. I'll head over to the Q&A session. We have a few questions from participants. Question number one goes to Honorable Priscilla. Someone saying that petty offenses are, the idea of decriminalizing petty offenses is a wonderful idea. We also have issues of resentencing, for example, in the Muruwatetu case. The question to you is there a goodwill from politicians to actually ensure that this is actually done? For example, we know that to undertake resentencing and also to hear out these cases, we need a bit of funds to be taken towards that direction. Are politicians willing to decriminalize these offenses, one, and are politicians willing to allocate enough funds to ensure that this is addressed? Another question, I think this can go to any panelist. From Mr. Hassan Kibet from GHM Advocates. He's asking, to secure certainty of administration of justice, is it possible for the judiciary to have a long-term financial budget under our current laws? So I'll give this opportunity to Honorable Priscilla to maybe just give us a quick response to those two questions. Over to you, Honorable Priscilla.
Thank you so much. Parliament is the lawmaking organ and judiciary is the law enforcement organ. So that relationship, and that's why we keep going back to the interdependence of the organs. So Parliament is seized of its obligations as a lawmaking organ. But what usually happens is that some of these pro-people laws or very subject matter laws have to be originated from somewhere else. And so the judiciary, either through the NCAJ or through the Attorney General, and you will see in the BBI, because we do not have the Minister for Justice, where some of these draft bills should, for example, originate, then the AG now, similar to the case in Ghana, will be allowed to perform the duties of a Minister of Justice. And so it is true that these bills, like decriminalizing petty offenses, that would be amendments to the penal code. If you ask Parliament to originate that process, it will take too long. So the best is for the judiciary, together with other actors, for example, including ICJ and other development partners, to originate a draft bill. And then now that draft bill can find its way to Parliament. And Parliament is a place where this JLAC, for example, Justice and Legal Affairs Committee, would then be interested in a matter like this and would then move the bill and with the offices of the Attorney General. It's a long overdue project. I know that ICJ, we have it in some way, but I think that we need to go back to it, because part of the reason for the backlog is actually a problem of the laws that we have. And part of the reason for police corruption and criminalizing poverty is some of those things. So that needs to be done. And I agree that it may not be a priority for politicians, but if it is put on the table, I mean, as long as we don't do it now, we are a year before elections. So if we can try to do this immediately after elections, I think that this is a project that can fly. I think the other one is on the funding, and it's going to be a long conversation, and I'm happy that Martin is here and Dr. Victoria and Jacqueline, because this parliamentary scrutiny and the relationship between the two organs is something that is going to need maybe a different sort of forum. Because when I was in Justice and Legal Affairs, I saw what role parliamentarians can play in supporting and protecting the judiciary's funds. And that might be something that we want to pursue. The new Chief Justice, the Madam Chief Justice, I think those are some of the things that maybe if we have a lecture or a webinar around the first 100 days for the new Chief Justice, I think those are some of the conversations we can have. But there is indeed a role that parliamentarians can play in ensuring that the judiciary has sufficient funds for access to justice. Thank you. Thank you very much.
Thank you so much. Another question to Dr. Victoria. Maybe if you would like to chime in a little on those questions I've asked earlier, is Dr. Victoria, you raise an important question on the indignity of some courts. Should the judiciary do a proper needs assessment to establish what needs it has and convene a special session to articulate the need for adequate funding? And this also speaks to what Jackie had actually mentioned, talked about. Could it be that the parliament doesn't really appreciate and understand the need for judicial funding? Is this I mean, these are very pertinent questions that participants are asking. Over to you, Dr. Nyandazi, and then maybe a quick one from Jackie and then Martin.
Yes. So first of all, the first question you raised to all of us is a question in the chat section about by Hassan Kibicho about since the judiciary's budget must be subject to parliamentary scrutiny, can the process be insulated from political interference? For example, coming up with an objective vetting criteria. I think there was another one as well with regards to whether there can be long-term budgets. So I find that whether long-term budgets are quite tricky. Why? Because we've talked about here about the inflexibility of long-term budgets. And as we've seen with COVID-19, the COVID-19 pandemic, there are things or expenses that crop up that hadn't been budgeted for or expected. And so having a long-term budget is quite tricky in that sense. And then secondly, it's all about the law. The supreme law of the land is the Constitution of Kenya. And as we've stated various times, Article 173 requires for budget estimates by the Chief Registrar of the Judiciary to be submitted to the National Assembly each financial year. So when we talk about long-term budget, how long is long-term? So that is the danger of it. But then with regards to having what the other question about insulating budget, judicial budget from political interference, I agree, and I had also stated as well that having a cap really helps. Having a cap, for instance, saying not less than 2% or something of the national budget should go to the judiciary and so on, is quite helpful in terms of insulating. And then the wording is also important. From what I've said not less than. So that means that it can be more, but no less. And then always we can see as well that laws always get revised depending on the particular situation of a particular country. And as we've seen, the budgeting happens at the beginning of each financial year. So that then enables, if there's a change in law, it then will not operate that particular year, but the next financial year. So that gives a bit of leeway in terms of the changes of the law if that 2% has to be reduced, for instance, because of other urgent needs or because of inflation and so on. And so that could be a way to do that. And then also with regards to the question about the indignifying nature of some courts. And as well as I had mentioned, scrutiny is important because then we find that in Parliament, we have parliamentarians who are actually nominated to represent various groups. So to represent persons with disabilities, to represent women, to represent the youth, to represent and so on. So all of this, we need to also think about, as I said, stakeholders, and by stakeholders, I also refer to civil society organizations, which push for such the rights of vulnerable groups to work together and engage the judiciary when creating their estimates to ensure that they have or they earmark funds to specifically be directed at making courts accessibility friendly by having ramps which are low cost, and so on. So, and by having desks, we have gender desks in most of the police stations, or in most, even sometimes you'd find gender desks for gender-based violence and so on in many other places. So by having desks where you have judicial offices to assist persons, vulnerable persons, or self-representing litigants to do that. And a case in point, very briefly, is Taita Taveta Law Courts. The head of court there, the head of station there was actually one of the best, I think 2 years back, with regards to backlog and basically management of the court station. Why? Because you'd find that in that court, it's a new court station, relatively new, and you'd find that in that, when the court station was launched, and when it came into operation, there were not so many lawyers around there, or law firms. So you would find that most of the litigants were self-represented litigants. Most of them did not know English. Most of them did not know the proper way of putting a complaint to a court. So you would find that they would just state it as they would speak normally, or just how you tell someone your grievances and whatnot. And issues to do with, is this adequate evidence? How can you prove this? Then would lead to dismissal of such cases. So you find that the court station there was able to help those particular vulnerable litigants to be able to have templates and to have things explained to them, that this is how you actually file a case, instead of letting people file things that may be dismissed or will certainly be dismissed in court. So yes, certainly having funds earmarked and having the judiciary engage with the relevant stakeholders on needs for vulnerable groups, particularly persons with disabilities, is quite important. Okay, that's all.
Dr. Miandazi, over to you, Jackie. Jackie, I think we've spoken about the issue of judiciary fund, whether we should have a cap or not, whether we should have a minimum or a maximum, and the fact that we can see that politicians in most cases, in a lot of jurisdictions, are using the issue of allocation of funds as a negotiating card between whether in judicial appointments or whether in terms of other accruing benefits that these judicial officers should give out. Over to you, Jackie. Maybe you can give us one or two comments before we go to Martin.
Okay, thanks, Silas. I think both Honorable Nyokabi and Victoria have addressed the questions that were raised very comprehensively. So I'll just add very briefly on my views towards the questions that have been asked. So you ask about, so before I go to the general question that was posed to all of us, you've asked about the percentages or the minimum, or just stipulating a certain amount. Just as I had mentioned earlier in my presentation, there are arguments for and arguments against providing a threshold. So while I hear the very reasonable proposal by Honorable Priscilla for having earmarking, having it capped at 1 or 2%, what I had stated was that at IEA, we've thought about the issue and had discussions around it and looked at the pros and cons of having a threshold. And our view at this point is that putting threshold on the level or the amount of funding may not be the best way to go. And the reasons why, as I explained or as I had stated, was because it does not, first of all, the funding must always be based on a needs assessment. So what are the current needs? I think the judiciary should be able to address itself to, or should be able to provide proper line justification for what exactly are the main priority areas, what exactly it would take for them to effectively dispense of or discharge their mandate. So what the level of funding should be aligned to a costing of the functions. And again, this would guarantee value for money in the long run, and would also enhance citizen participation. You see, the challenge that we see here at IEA with that threshold, and especially when I talk about the value for money argument, is sometimes you may allocate resources. And like the example that Honorable Nyokabi has mentioned on the World Bank project, vis-a-vis the funding that they received from the construction of their courtroom using funds from the World Bank, compared to the funding that they received from the national government. You see, those disparities are one of the things that arise when you provide resources. So if you I can't say that it's overfinancing, but if you provide, say, or you suggest that there must be a certain threshold, then it would mean that that money has to be spent, and it would actually, in one way or another, either lead to, if it does not align to the needs of the institution at that point, it would either lead to things like inflated procurement processes. Value for money will not be achieved for some projects in some instances. So it could be either, it could go either way. So that's why in our view, we propose that the allocation should at all times be based on a needs assessment. Then to respond quickly to the question on the long term.
Yes, quickly. Because of time, maybe just quickly give an overview. Yes.
Yeah, the question on the long-term financial budget under the PFM, under the law, and the requirements right now is that all institutions participate in participation of, participate in the process of the medium-term expenditure framework. So they're supposed. So the MTF basically is sort of a long-term. It provides a 3-year projection of how the institution, the main targets of the institution, and how they intend to utilize the funds that they will be requesting from the public purse. But that one is usually just a projection of the intended expenditure. It's not. It's when during each year it's revised, and the budgeting is then done according to the requests that are done for that particular year. I think I'll stop there.
Thank you so much, Jackie. Martin, can you take maybe a quarter of a minute to just give us your response?
Yeah, I think that we need to continue having these conversations in order to get a middle ground between the needs-based approach, which Jackie and her organization favor, and the threshold approach. I think there is something to say for both, because funding to the judiciary should not be left to be open to political fluctuations. That's what the needs-based approach does. You imagine this very little example from Uganda, where the judges have extended their term limit to 7 years, and it's very unpopular. And so people have gone to court. They have challenged this, and the court has agreed, with the people that the parliamentarians cannot extend their term limit to 7 years from 5. And then when the courts come before the parliament to present their budget, then the parliament then turns this budget and the process, to some ping pong, just in order, to express their dissatisfaction with the decision of the court. So I think we need to continue these conversations and find a middle ground between the needs-based approach and that minimum threshold approach.
Okay, thank you so much, Martin, and thank you, our panelists, for such great insights. And I think in now closing, noting that we're out of time, I think the all important question is that Kenya is in a period of transition. We just recently concluded the process, or rather we are in the advanced stages of concluding that process of the recruitment of a new Chief Justice. So in closing and in making your closing remarks, panelists, in just 1 minute or two, what do you think are the priorities for the CJ in terms of addressing this issue of funding, and what creative ways can they use in just a minute or two? And this time, I think I'll start with you, Martin. Your sentiments and your closing remarks. Martin? Okay. Yeah, okay.
I think the CJ needs to take a double-pronged approach where she takes deliberate measures to influence budget policy makers by winning trust through transparent, detailed budgets with strong business data and metrics, finding ways to save taxpayers' money, reporting back on progress, ensuring full accountability, educating legislators and staff about the courts, explaining the impact of cuts in concrete terms, and remind legislators of the judiciary's core mission and build broad coalitions with non-traditional partners. Secondly, and finally, I think the Chief Justice needs to, in the medium and long term, engage the public so the public can be an ally in advocating with them and for them in favor of increasing and maintaining adequate levels of funding to the judiciary.
Honorable Priscilla.
Thank you very much. I think also just quickly on the priorities for the new Chief Justice, I would still insist on the interdependence of organs. And so an inter-organ sittings or sessions, the executive and the legislature, with the two objectives. In fact, the new Chief Justice can even do a greet and meet with the President and with the speakers of the Assembly and the Justice and Legal Affairs Committees and the Treasury. And the two objectives would be, one, the 40 judges problem. Remember that judicial resources are also personnel issues. And so that question of personnel must be redressed. And then two is adequate resources. And the reason I personally really favor the minimum threshold is so that you don't have to do these relationships all the time, because they have a bit of they erode a bit of your independence. Because as you go to the table, as you ask, so will you be asked for other favors? You know, the table is a place of trading. So that you don't keep trading, I would prefer a minimum threshold approach. I go once, and I have done it before. If you look at the National Government Affirmative Action Fund, it is 2 billion Kenya shillings every year. And so you now no longer need to, you know, keep begging Treasury for that money. And just lastly, also on the minimum threshold is what we were calling weaponization of the budget process. Remember, our budget process can be weaponized. That every time the judiciary gives an unfair judgment, for example, on CDF, that weaponization is followed. So even for groups like ICJ, I hope that this is not the last conversation we are having on the matter, that we are going to have many more. Thank you very much, and wishing the new Chief Justice all the best, and all of us all the best with better access to justice and legal reform and judicial reform days. Thank you.
Thank you so much, Honorable Priscilla. We go to Jackie, your closing.
All right, thanks again. So in closing, I'll actually just speak from what has been said by Honorable Priscilla. The priority should be, if we look at the interdependence of the main institutions, the new CJ should just basically find innovative ways for more effective bargaining skills, especially with the parliament. And then they should be able to demonstrate or illustrate the consequence of underfinancing. So it's always easier to convince someone to provide you with the resources that you're requesting if you can provide evidence or illustration of what would be the consequence of underfinancing. So I would, so that relationship needs to be established, and then they need to do a proper, as I had mentioned again, needs assessment, computation of the functions, because this will provide them with the evidence to illustrate what is actually required. Lastly, the last thing that I think should be done as a matter of priority is, as they have indicated themselves as the judiciary, automation of various processes is one of the priority areas, and it would go a long way in helping them save, either raise or increase the resources that they are able to also raise through their own source revenue generation, and also to save the little available resources that are there to go towards more effective public service delivery. So those would be my concluding remarks. Thanks again to ICJ for having us, and to all the participants for joining in. Thank you.
Thank you. We go to Dr. Victoria.
Yes, so very quickly, noting that time is running. So I agree with all the other speakers. And to add on to that, as I said, stakeholder engagement is really important for the new Chief Justice, because organizations like the ICJ Kenya have been thinking about judiciary funding, amongst other things, for a long time. And so it's, instead of reinventing the wheel and starting on a clean slate, it's important to engage stakeholders to find out what are the suggestions out there, and so on, even as a new CJ thinks about a way forward about dealing with judiciary funding, as well as what has been said, just engaging the National Assembly and engaging the Office of the President about judiciary funding and so on, because as we've discussed, there's a lot of politics that go into the whole issue about judiciary funding, as well, not forgetting about scrutiny and how important it is, and audits. So just for the new CJ to just note that even as there are budgets, there needs to be proper processes and proper accountability for budgets that the judiciary presents. Okay, that's all. Thank you, everyone, and thank you, ICJ Kenya, for organizing this discussion on a very important topic. Thank you.
Thank you so much, Dr. Nyandazi. I would like to give 1 minute, just 1 minute, to Honorable Priscilla Nyokabi, so that she can wear her hat as an ICJ Kenya council member, to just say one thing, and then maybe we can close. Over to you, Honorable Priscilla.
Thank you very much, and really to be happy that ICJ continues to have these conversations. And I want to dedicate the 1 minute also to the disability groups. And I like that point came up earlier about accessibility of courts to disability, but also more importantly, sign language, for example. I think that courts are lagging behind in terms of ensuring that persons with disability in all cadres can follow the conversations going on. So that's going to be an important, even in employment. Judiciary is now at 1.6% of employing persons with disability against the constitutional target of 5%. Now that they have achieved the 2/3 gender rule, I think it is going to be important for the new Chief Justice to put a lot of effort on persons with disability, and as another reason why increased resources then would help that other group. I'm also hoping that we continue with these conversations, because it is not over. And many of the reforms in the judiciary have unfortunately come from outside. I think we are hoping to see how well the new Chief Justice can begin to originate reforms from within the judiciary. And that is why you see the resistance, for example, with the ombudsperson. If the reforms are outside-led, then there will be some resistance. But why can't we see reforms that are inside-led with partners like ICJ? Thank you very much, and really a fruitful discussions. I think for us lawyers, and I've been asking Elsie, you really need to get a CLE. I mean, here we should have gotten a whole 2 CLE points for all of the conversations. Thank you very much.
Yeah, thank you so much, Honorable Priscilla. And I think this brings us to a close of today's webinar. Remember, it will also be accessible, for the recorded version of it will be accessible on our social media platforms, including YouTube. So you can always go back and look at the discussions and engage further in those conversations. So on behalf of the ICJ Kenya Council again, and the ICJ Kenya Secretariat, we take this opportunity to extend our very sincere gratitude to our distinguished panelists who joined us today. We thank you, Jackie Kagume. We thank you, Honorable Priscilla Nyokabi. We have Dr. Victoria Nyandazi and Martin Masega. Thank you so much for taking your time to share your insights, your experience, and your knowledge.
Yeah, and finally, we would like to extend our gratitude to our esteemed participants for joining us in this webinar today. and for your active engagement, and our entire production team for your great efforts in putting this together. This is the first in the series of rule of law webinars that we are going to hold on judicial independence, and particularly on the Judiciary Fund. And we hope that you will keep tuned to ICJ Kenya webinars. Until next time, asanteni and have a great week ahead.
Bye.